let's talk about the case of Baquirin versus Dela Rosa, GR number 233930. This is an en banc case decided on July 11, 2023, and the pedente is Justice Singh. So what happened here was several lawyers, as members of the Integrated Bar of the Philippines and as concerned citizens, specifically one of them is Evelyn Ursua, who when I read the case, I was like, why is this so familiar? Because of the Ursua versus Joseph case. So that's interesting. I don't know, seeing people's names come up over and over again. The legal world is real small. Anyway, so the petitioners here, as concerned citizens and members of the IBP, came before the court, and the petition is a petition for mandamus and a prayer for the issuance of a writ of continuing mandamus, seeking what? To compel the respondents to perform their duties under the Constitution, pertinent laws, and treaties pertaining to violations of the right to life, right to life and investigation and prosecution thereof, and to report to the court the measures they will be taking in carrying out such duties. So the factual background for this case would be your Upland Double Barrel, consisting of Upland Tokhang, and Project High Value Target, Low Value Target. Very cool names, right? And the respondents here would be the heads of the PNP, the chairperson of the Commission on Human Rights, and the PNP, and the secretary of the DOJ. So it's Dela Rosa. It would be former chairperson Gascon and former secretary Aguirre. So basically PNP, CHR, DOJ, right? That's why they were named, because the petition is against the departments, right? The capacity as leading those departments. Because what the petitioner said is that, okay, so following the directive of then President Rodrigo Duterte in July 2016, so the PNP led the efforts for the suppression of crime and illegal drugs under Upland Double Barrel, right? And then in Upland Tokhang, this involved police officers visiting the homes of suspected drug officers to persuade them to stop using or peddling illegal drugs. And then Project High Value Target, Low Value Target was focused on big time and small time drug personalities. So I suppose that's what's a medium drug personality? Anyway, also their accomplishments. Their accomplishes, okay? They weren't focused on their accomplishments. Though I suppose if you're a big time drug personality, you accomplished a lot of things to get on that list. Anyway, so what was reported with these campaigns was, the number of surrenders, how many drug pushers, drug users surrendered to authorities, and then how many drug personalities were apprehended, right? But at the same time, the spate of killings of suspected drug personalities allegedly committed by or with the complicity of state agents was like a huge topic, and it remains to be one to this day. So basically, the varying statistics on the aforementioned killings from the PNP were published in several news articles, and then because the number wasn't, who knows how many there were, right? So the petitioners, based on this, concluded that there was a lack of genuine, thorough, prompt, impartial, and independent investigation thereon, on the killings, right? And then the petitioners alleged that apart from some, quote, high-profile cases, the lisp is lisping today. Apart from some high-profile cases and possibly a handful of others, many alleged extrajudicial killings remain uninvestigated. Hence this petition. Okay, so basically the argument of the petitioners was that in the capacity as heads of the CHR, the DOJ, and the PNP, the respondents failed to adequately perform their duty to prevent violations of the right to life and to investigate and prosecute the same under the Constitution, pertinent laws, and human rights treaties to which the Philippines is a party. Thus, they further contended that the respondents should be directed through a writ of continuing mandamus to perform a bunch of duties that I'm not going to get into because, spoiler alert, they lost. Okay? The court ruled that the petition was bereft of merit. But basically, it was compelling them to report to the court the measures that they would be taking in carrying out such duties established under the Constitution, pertinent laws, and human rights treaties to which the Philippines is a party. Okay? The CHR maintained the position that it had actually fulfilled its and continues to fulfill continued to fulfill its constitutional mandate to investigate the violations of the right to life, and that its power to investigate such violations is also not ministerial in nature because, remember, this is a mandamus petition. The CHR also countered that the petitioners failed to establish any breach of duty on the part of the CHR. Then they also didn't show that the CHR's conduct of investigations into the deaths in relation to Upland Double Barrel fall short of the standards under international law. Also that the petitioners were unable to prove that they had no other plain, speedy, and adequate remedy in the ordinary course of law against the CHR because, again, mandamus, right? Now, for Dela Rosa and Aguirre through PNP and DOJ through the Office of the Solicitor General, they contended first that the petitioners had no standing to file the present case, and second, that a writ of continuing mandamus is limited only to the enforcement of environmental laws. And then, even assuming if that wasn't the case, the writ should still not issue against them because the acts which the petitioners seek for the PNP and the DOJ to perform are not simply ministerial but would require the exercise of discretion. Okay, basically requiring the PNP and the DOJ to submit periodic reports to the court would also effectively make the court the supervisor of the PNP and the DOJ, which would be in violation of the basic constitutional precept of separation of powers. So basically, the issue at hand here is the issuance of a writ of continuing mandamus to compel the respondents to perform their duty to protect the right to life and to submit periodic reports thereon to the court warranted in this case. And the ruling of the court is no, it's not. So why did they rule this way? First, the court went into what is a writ of mandamus, which I love a little reviewer because I keep getting confused. I mean, like, okay, when you review it, it's like top of your mind. Then you review another thing, and then you forget. And then it haunts you because you feel so stupid. But it's okay. So first it goes into what is writ of mandamus. Then it goes into why the petitioners had no standing. Then the case goes into even with the no standing thing, then the transcendental importance, and then also that the petitioners had failed to establish any neglect on the part of the respondents of any duty under either the Constitution, law, or international treaty. So, let's get into it. Okay, the ruling of the court. First, again, it's bereft of merit, right? So first thing they talked about is what is a writ of mandamus. So a writ of mandamus is a remedy granted by law when any tribunal, corporation, board, officer, or person, unlawfully neglects the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station. Or second type of mandamus, when any tribunal, corporation, board, officer, or person unlawfully excludes another from the use or enjoyment of a right or office to which such other is entitled. So, neglecting to perform an act which is specifically enjoined as a duty by law, or unlawfully excluding another from the use or enjoyment of a right or an office to which such other is entitled. Mandamus has been recognized as an appropriate remedy to raise constitutional issues and to review and or prohibit or nullify, when proper, acts of legislation and executive officials. Okay? Now, for a writ of mandamus to be issued in a case alleging an officer's neglect of a duty, which is this case, no one's being deprived, no one's being unlawfully excluded by another from the use or enjoyment of a right or office to which such other, or the first person, is entitled. Anyway, so here the petitioners are alleging officers' neglect of duty. What has to happen for the writ of mandamus to issue is a concurrence between a clear legal right accruing to the petitioner and a correlative duty incumbent upon the respondent to perform an act. This duty being imposed upon them by law is required. Okay, so again, there has to be a concurrence between a clear legal right accruing to the petitioner and, on the other hand, a correlative duty it's my arch nemesis. A correlative duty incumbent upon the respondent to perform an act, and this duty has to be imposed upon the respondent by law. So that's the requirements. The respondent must likewise be shown to have actually neglected to perform the act mandated by law. So a right, a duty, neglect of that duty, actually shown to be neglected. The duty must likewise be what? Ministerial, rather than discretionary in nature. It's gotta be ministerial. Because otherwise, the courts, if they would grant the writ to perform a discretionary duty, that would be subverting the authority of the respondent to exercise discretion, right? So that's why it has to be ministerial. A mandamus petition will also not prosper unless it is shown that there is no other plain, speedy, and adequate remedy in the ordinary course of law. Okay? Writ of Mandamus. Quick reviewer. Now, the court said that just on the procedural aspects, the court should be dismissed, which is first, that the petitioners had no standing to file the petition, and second, they violated the doctrine on the hierarchy of courts. So, first discussion, legal standing. Legal standing is what? It's the right to appear before a court of justice on a given question. It calls for more than just a generalized grievance, particularly referring to a personal substantial interest in a case, such that the party has sustained or will sustain direct injury as a result of the challenged governmental act. Okay, so you need to have standing, because there's a general prohibition against third-party standing. Now, this isn't in the case anymore, but I'm still doing my poly review, so let's just go into it. What's an exception to the prohibition on third-party standing? Facial challenges, right? A facial challenge on if it's something to do with free speech, or if it's a penal law to do with free speech, that would be Decini, right? The Decini case. Anyway, notwithstanding, the constitutional cases often brought through public actions and the relief prayed for is likely to affect other persons. Non-traditional plaintiffs have been given standing by the court, provided specific requirements have been met. One such example would be when someone sues as a concerned citizen, provided that they would allege that provided that this concerned citizen alleges that he has been or is about to be denied some right or privilege to which he is lawfully entitled, or that he is about to be subjected to some burdens or penalties by reason of the act complained of. So here, the petitioners filed their suit as concerned citizens, saying that they had a demandable right that they can enforce against the government agencies for the due performance of their duties with respect to the protection of the right to life. However, the court did note that there were no allegations in the petition of any injury actually suffered or an injury that was about to be suffered by the petitioners by reason of the alleged non-performance of the respondent's duties. So there, as the standing, okay. And then the petitioners also invoked the original jurisdiction of the court because the protection of the right to life and the rule of law are at stake, without mention of the absence of any other remedy that they could have taken against the respondents. Because remember, a mandamus petition will not prosper unless it is shown that there is no other plain, speedy, and adequate remedy in the ordinary course of law. So, one, they didn't do the plain, speedy, adequate remedy in the ordinary course of law, right? They didn't show that there was nothing else available. And then as to standing, they didn't show that, they had suffered or they were about to suffer because of the alleged non-performance of the duty by the respondents, okay? But the petitioners admitted their lack of standing and their failure to observe the principle of the hierarchy of courts. Nonetheless, they implored the court to dispense with these procedural requirements due to transcendental importance of the issues raised in the petition, because the government's anti-illegal drug operations resulted in an unprecedented number of deaths nationwide, right? So, the lack of genuine, thorough, prompt, impartial, and independent investigations of allegations of extrajudicial killings related to the government's anti-illegal drug operations endangers the lives of thousands of Filipinos all over the country. Okay? So, they're like transcendental importance. You should probably look at this, right? Maybe we can do away with the procedural niceties and deal with this, because it seems like a big problem, right? But the court discussed how it has ruled in other cases, which is that the general invocation of transcendental importance is not a talisman which automatically excuses compliance with technical rules of procedure. You can't just say, oh, but this is like super important though, so can we just deal with it anyway? Among the factors in the determination of an issue's transcendental importance to warrant the relaxation of procedural rules are A. Clear or imminent threat to fundamental rights. B. The presence of a clear case of disregard of a constitutional or statutory prohibition by the public respondent agency or instrumentality of the government. And C. The lack of any other party with a more direct and specific interest in raising the questions being raised. So, again, those are some factors that are taken into account by the court in the determination of an issue's transcendental importance. So, one petitioner say, but transcendental importance, and then the court has to see, but transcendental importance, they gotta check, is there a clear imminent threat to fundamental rights? Is there the presence of a clear case of disregard of a constitutional or statutory prohibition by the public respondent agency or instrumentality of the government? Is there a lack of any other party with a more direct and specific interest in raising the questions being raised? So, some factors to consider. The facts must be undisputed, so only legal issues must be present, because the court is not a trier of facts. So, facts must be undisputed, only legal issues must be present, and proper and sufficient justifications must also be given why the court should not simply stay its hand. You have to give clear, proper, and sufficient justifications as to why the court should by this whole transcendental importance thing. This is because the alleged transcendental importance of the issues raised will be better served when there are actual cases with proper parties suffering an actual and imminent injury. Because what is another exception to the prohibition against third-party standing? Transcendental importance, okay? Basically, what they're saying is, so you have not suffered, and you're not in danger of suffering because of this. So it might just be better to actually settle it not when someone is actually suffering, but when, it can be as applied to the case at hand, So the court must exercise restraint in cases that fail to properly present justiciable controversies brought by parties who fail to demonstrate their standing and observe the hierarchy of courts. Otherwise, it may be rendered ineffective to dispense justice as cases clog its docket. So here, petitioners failed to show any injury that was so great or imminent on their part that so they didn't have standing, and the court could not instead adjudicate the issues raised on the occasion of an appropriate case. Basically, they failed to show that they had any injury, but they also failed to show that it would be so imminent on their part that the court shouldn't wait to adjudicate the issues on a different occasion when it's raised in a more appropriate case instituted by parties who suffer from direct, substantial, and material injury. Likewise, they were remiss in justifying their direct resort to the court and their choice of remedy, because again, they didn't show if there was another plain, speedy, and adequate remedy in the ordinary course of law. So on these issues alone, petition should be dismissed. But that's not what the court did. They still talked a little bit more on the failure by the petitioners to establish neglect on the part of the respondents. So the first part was just like a nice little reviewer on transcendental importance. It's a nice little reviewer on standing. Nice little reviewer on mandamus. And here also the court talks about another important part of mandamus, which is that the duty, that the respondent must likewise be shown to have actually neglected to perform the act mandated by law. Now, the laws that would have been, giving this duty onto the respondents here would be RA 6975, which mandates the PNP to enforce all laws relative to the protection of lives and investigate and prevent crimes and bring offenders to justice and assist in their prosecution, among others. Also, the Admin Code designating the DOJ as the state's principal law agency, primarily tasked to administer the criminal justice system in accordance with the accepted processes thereof, consisting in the investigation of crimes, prosecution of offenders, and administration of the correctional system. And then for the CHR, it's an independent office which the Constitution principally created to investigate on its own or on complaint by any party all forms of human rights violations involving civil and political rights. So, the respondents, as the then respective heads of the PNP, DOJ, and CHR, were bound. Yeah, the duty existed to prevent violations of the right to life and to investigate and or prosecute such violations when they occur. Now, the petitioners asserted that the respondents failed to discharge these duties to investigate and to prosecute violations of the right to life and to adopt positive measures to prevent any and all further violations of the right to life in the course of the campaign against illegal drugs. So, what they did to substantiate this claim is to cite the absence of reported convictions for extrajudicial killings. So basically, they didn't do the duty because, look, there's no convictions for EJKs despite a lapse of 1 year. And also, there's a lack of public disclosure on any actions taken by the DOJ or the PNP or the CHR against persons who have been identified to have been involved in the killings. But then also, so now this is where the court says, this is starting to fall apart. Why? Because the CHR did commence its own motu proprio investigations on the alleged killings. Okay? And this was admitted by the petitioners. And the DOJ did direct the National Bureau of Investigation to investigate the reported killings allegedly related to the campaign against illegal drugs. So these are both admissions by the petitioners. So the court said that what was offered instead were conjectures and conflicting statements, and outside of that, the petitioners offered no concrete proof that the respondents were actually remiss in their duties, that they hadn't even requested the respondents to furnish them with the information, that it wasn't even shown whether they asked for the information. So the court said that these are just bare allegations which cannot be given credence. All the more so with respect to the CHR, since the CHR really did conduct an investigation on the extrajudicial and drug-related killings and the list of trainings that they conducted for the police and military sectors. In 2016 to 2017, this list of trainings was also submitted. Now, lastly, the court noted the following treaties guaranteeing the right to life, which were invoked by the petitioners to support their averments, which would be the International Covenant on Civil and Political Rights, so ICCPR, the Convention on the Rights of the Child, the International Convention on the Protection of the Rights of All Migrant Workers and members of their families. So the court here said that while state parties such as the Philippines are bound to protect the right of every human being to life, they are allowed to do so in accordance with their national law and to the extent of their available resources. In consideration thereof, state parties are essentially obligated to establish a system of accessible and effective remedies through judicial and administrative mechanisms which ensure that any person whose rights are violated shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity. B, any person claiming such a remedy shall have his right thereto determined by competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by the legal system of the state, and to develop the possibilities of judicial remedy. And C, the competent authorities shall enforce such remedies when granted. So basically, state parties to the ICCPR, the CRC, and the CMW are afforded a wide latitude in complying with their obligations they're under owing to their sovereignty, because you're bound to protect the right of every human being to life, but the mode of protecting, or how they actually achieve this end, is in accordance with national law and to the extent of their available resources. So, the petitioners cannot impose on the respondents the standards and characteristics of investigation which they deem to be appropriate and sufficient through a mandamus petition, as it lies only to compel the performance of what? Ministerial duties. So basically the court said, even under these treaties, it's determined by national law. So that's not ministerial, okay? That's not ministerial. That's discretionary. We can't compel that performance. So, one last thing, remember, there's the whole thing of like the writ of continuing mandamus. Isn't that just for environmental cases? And the court said, yeah, it is. OSG was right there. The writ of continuing mandamus is available only for environmental cases, and requiring the submission of periodic reports on the discharge of the respondent's functions, which the court just said were not ministerial, would violate the fundamental doctrine of the separation of powers, which serves to temper the official acts of each branch of government. So, basically, due to lack of evidence presented and the claims being speculative or mere surmises, the court had no jurisdiction to rule upon the contentions of the petitioners. So, therefore, the petition for mandamus was dismissed. Okay. So that's it for the case of Baquirin versus Dela Rosa. GR number 233930, July 11, 2023. And this was an on-bank case, okay? And let me count. Justice Leonin had a separate opinion, but 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. So, yeah, 13 justices concurred. So pretty overwhelming majority there. Okay. That's all.